So what I intend to do is mostly talking about from a practitioner's point of view, working level, caseworker point of view, and not so much step into the legal stuff during this presentation. But the topic here is really about the future of 1FA, and I'm going to talk about it from a Canadian perspective mostly. So this is just my way of saying that whatever I'm talking about today is not the opinion of my agency. It's my personal opinion, so thank you, you too. Maybe a little personal story about me is that the topic of exclusion, I guess, came in very early in my career. I mean, as soon as I left the academic books doing my master in human rights law overseas, I stepped into a job that was actually my articling position to officially become a lawyer in Canada. And I had the very fortunate chance to do it at the ICTY, so the International Criminal Tribunal for the former Yugoslavia. So I jumped into ICL, hardcore ICL immediately. I did a short stint at ICC as well, before about 2 years later, getting a call from Susan Shop and in the GTA, and I was like, there's a war crimes unit in Toronto? Yes, please, I'll be coming back home. And I did, and I must say that I did go through a little legal culture shock. And I did that more than once in my career, because when you step out of an international criminal tribunal, where the evidence is packed in a room, for one case in a room as big as this one, and you come to work with immigration, refugee cases in Canada, all of a sudden your evidence about this thick, to sometimes this big, to sometimes a couple of boxes, but that's the extent of it. As it was discussed before, most of the cases involve evidence that is focused on the claimant's testimony and documentary evidence, and that's it. It was a bigger shock even when I came to Ottawa later on, where I am now, and had to look at work on overseas files. So including like resettlement cases, and also then you're jumping to files that are about this big. I did one trip to Nepal, the refugee selection process. It was the resettlement interview part, after they were all selected by UNHCR. And it's a much different context again. You get just a few minutes with the people, it's 45 degrees, you got a small room, you got the whole family there, and you have to decide whether or not there are grounds for exclusions. The ballgame is very different from what I started with at the very beginning of my career. But exclusion and ICL are very well connected. And why exclusion is an important question when determining its future. ICL, cases before international tribunals, are mostly focused on those who bear the greatest responsibility. And exclusion, however, is focused on people at all levels of the spectrum of impunity, if you wish, from the commanding structure to the foot soldiers. The question is, however, are we moving in the right direction? We're just going about, when we're talking about big fish and little fish, which fish exactly should we be talking about, and what net should we use in the future of 1FA to capture people under the exclusion clause. So to address the future, I'm going to look mostly at past trends, because that's going to help me predict what maybe the future is going to hold. Also looking at current challenges to determine what risks lie ahead, and also looking at maybe what's on the radar that people should be aware of in terms of 1FA. So moving quickly to past trends. Now I don't have a DeLorean, and so I can't go back in time or go in the future necessarily. But if my magic 8-ball is telling me something, is that what you see in previous decisions, especially in Canada, federal court's decision, and what's happening now, is what's going to determine what's going to happen in the interaction between ICL and 1FA cases in exclusion law. And going back in time, at the very beginning when the Refugee Convention was drafted, the main instruments that existed at the time was mainly the Nuremberg Charter, You had the 1949 Geneva Convention, the Genocide Convention. But at the very foundation, when you look at the raison d'etre of the exclusion provision, here I put a quote from the UK Supreme Court in the GS case. That's just a way from the court to interpret in their own words what maybe the undeserving guidelines meant. And it also gives you a good idea of how the court is going to do its analysis and the steps that follow. So when you look at Nuremberg, the text was used early on in one of the most famous decisions in Canada. It's been already mentioned here. It's mentioned many times, and it's the most referred one. If you look at Ramirez, it refers directly to the Nuremberg Charter. I don't want to get into the legal language. I just want to point out to the fact that at that time, in one of the most important decisions, the Federal Court of Appeal made a direct link to the Nuremberg Charter to interpret what complicity meant. And you look at the future, more recently, in the 90s, you had a lot of body all of a sudden that came out in the jurisprudence overseas that didn't exist for about 40 years since the Nuremberg tribunals. And that jurisprudence came out of the ICTY and the ICTR. And in Refugee, again, references were made to the jurisprudence from those two bodies to help interpret. In that case, it was mostly about interpreting the crimes definition than the complicity itself, although they did consider basically that counseling amount was the equivalent of instigating in ICL. However, it was referred to. And more recently, if you look at the Zakola decision that was already mentioned, now we have references to the ICC. So my point is quite simple, that this is a trend that existed before in key decisions, and it's going to exist in the future as well. We're going to get key decisions from the ICL community coming out, and we should expect as practitioners that whether you're doing cases before the IRB, whether you're making decisions on those cases, or you're doing those cases at federal court level, you may hear arguments, or you may have to make arguments yourself based on those future decisions from the ICL community. You should be ready for those arguments to be made. Now I'm going to jump into the current challenges to establish exactly what risks lie ahead. One main topic that came out today is consistency. When you look at exclusion law, refugee law, and you look at ICL, there's essentially two streams of law. They're distinct, yet they're a link, especially through the Article 1FA and its direct reference to international instruments in ICL. However, sometimes if you don't apply them appropriately, you may burn or freeze yourself. One thing that's really coming out as an important topic recently is convergence between ICL and refugee law, especially in the field of 1FA. And while consistency is sometimes looked at as a risk to convergence, I also want to bring up the positive. What is significantly valuable to practitioners is that all of a sudden in the last decade or so, we have an enormous body of jurisprudence that has come out. So that's not only questions of law, that's also questions of facts. You have decisions from international tribunals and courts that help you as a practitioner look at what were the circumstances under which war crimes and crime against humanity were committed. It helps you identify the dates of the armed conflicts of the attacks, who was responsible, what was the chain of command, which units were involved, in what area, who were the victims, names of the operations, also sometimes participation of external actors. And I'm talking about here about foreign states, and in some instances can be even people who were involved in corporations. Because the language of 1FA is not restricted to just the parties of a conflict just in their own state. And these are very important facts to have if you're doing a case on 1FA, because often it's much more difficult if you don't have all the context of a conflict. And I want to go back to some of the question about the current trends, and maybe we're seeing more exclusion cases. I see a direct link. We're not necessarily seeing more exclusion cases, but I think they're becoming a little bit easier to assess based on the fact that international monitoring, human rights monitoring, has improved significantly in recent years. Access to information from human rights report, court decisions such as the ICC, ICTY, ICTR, Special Court for Sierra Leone, provides you as a caseworker with a tremendous amount of information that you may not have for a case from the 80s, for example. Try working on a case from Colombia from 1986, and try working with a RUF case from Sierra Leone during the armed conflict, and you'll have a totally different amount of information available to you. In the context of 1F cases, that will help many cases move forward, and also it may increase the numbers of exclusion decisions that will be rendered. But as practical as that is, it's also sometimes frustrating from a practitioner point of view, because you know there's a tribunal that has a lot of evidence in its possession, and the decisions that are rendered do not necessarily give you access to all that evidence. It's only limited to the case of the person who's appearing before the tribunal. And as caseworkers, do we have access to all the material of the ICTY, the ICC, the ICTR? No, we don't. We have access to their decisions, but only in very limited fashion will we have access to their evidence, and info sharing with those tribunals can be an issue. And something to look forward to in the future, because some of those tribunals are closing. Special Courts for Sierra Leone is closing, ICTR and ICTY will eventually close, and they have massive amounts of archives of evidence that could be of use by multiple states. I'm not just talking from an exclusion perspective, but from a prosecution perspective as well. And the question is, how is that information going to be passed on to individual states to take action on cases that are before them? So I just talked about the evidence before the tribunals, but I want to reiterate the point that sometimes one of the biggest challenges for caseworkers is the fact that you don't have access to the evidence on site, especially if there's no international tribunals involved in the situation that you're faced with. If you're looking at Somalia, you're looking at other countries, it becomes a real challenge to have concrete evidence. So you have to resort to human rights monitoring. You have to look at Amnesty International, you have to look at Human Rights Watch, you have to look at UN reports. Special rapporteur from the UN have great reports sometimes as well. Other regional bodies like the Inter-American Court of Human Rights or its commission, including also the European Court of Human Rights, can be very useful in some instances. But it's one of the main challenges in terms of practice. And here is a picture of my last case as a hearings officer, I guess. No, just kidding. So I'm even getting involved in that one. I want to bring a personal story here because as an ICL-minded person, early on in my exclusion experiences, I really wanted to bring some ICL concepts into the equation. I think Joseph can remember me trying to really hard to get joint criminal enterprise cases going. And through trial and error, I realized how difficult it can be for some international criminal law concepts to be applied into the refugee exclusion parameters. Joseph already explained the challenges of proving a joint criminal enterprise at the criminal level, and why it's difficult to prove it at the refugee level. The fact of the matter is, there was one case where I worked on, and my advice is this for caseworkers. GC could be used in some instances, but only if a tribunal, international tribunal, has really defined what the GC is in advance for you, where the evidence has been heard and it's been defined. Because if you look at the case of the ICL, Special Court for Sierra Leone has already said you need to establish who was in the enterprise, the dates of when the enterprise existed. If it changed, you need to mention how it changed. These are all criteria that you can't really assess in a refugee case. And even if you have the best case before you, and you make the arguments, and I did a very well-structured argument, when the decision came out, there wasn't a one word on GCE. Instead, the RB did what I expected it to do, and it looked at the other arguments I made on the 6 factors and on the membership in the organization. Because introducing a new ICL concept all of a sudden before a decision maker can make them very uncomfortable. And also, there's some realities that have to be taken into consideration when we're looking at ICL concepts like GCE and trying to make cases of exclusion moving forward. When you're working on caseworkers in refugee cases, whether it's in Canada, overseas, in a refugee selection trip, refugee determination is supposed to be efficient, fair, and effective. And I put the word quality, but basically in accordance with the law is what I'm getting at. You're looking at the values of the IRB, you're looking at the values of the UNHCR in many aspects. And that reality is also very much influencing the daily work of everybody who works on those cases. If you're working in the ICTY, you're focusing on a single armed conflict most of the time with a quite an enormous amount of evidence. A lot of investigators, legal advisors, intelligence analysts. When you're working on your own and you have 30 cases that you have to move on each month before the IRB, and you have hearings every day, you have detention reviews, you keep moving on. It's very difficult to keep aware sometimes of the ICL developments because, let's be honest, a judgment from the ICTY is on average maybe 400 pages. Same thing with ICTR, the ICC, even an indictment, the charges of the ICC, some decisions I've read were like 500 pages close to them. So it represents a challenge when you have staff that are working on a lot of cases at the same time and they need to be kept abreast of everything that's happening, not only in the refugee world, the immigration law side, federal courts, but also what's happening in international criminal law. It's sometimes what's happening in the human rights side because some human rights decisions are actually linked to talking about convergence. We can also bring human rights law into the equation. So there needs to be awareness that we need to put in tools for staff to be able to adapt and be ready to follow the trends in ICL, but also establish their own grounds with refugee law. And often the solution is basically training before you get to that, you get to this point right here. So jumping into the what's on the radar for exclusion. A few things to be aware of as practitioners is, first of all, there's some courts that are going to close, like the ICTY. However, they have 2 very important final cases before them. They have more than that, but these are the 2 main ones, in my opinion. And it will have an impact in also sometimes how you analyze complicity. In the Mladic case, it's on genocide, but you're looking at the operational level on the site where the genocide happened. And I like that picture for 2 reasons here. Because not only does it represent the final stage of the ICTY, but also tells a story in that picture that represents some realities of the exclusion world as well. Look at the little chart at the bottom of the picture. You see 1990 to 2011, and there's different colors. The red represents when the crimes happened, and the allegations are. And the yellow is basically when the person was arrested and when the hearing started. In a lot of refugee cases, sometimes you can face a similar situation in exclusion cases, where the person is making a claim now, but the evidence and testimony about exclusion relates to 20 years ago. And that creates a huge gap in memory of the witness. It creates sometimes a huge gap in evidence, access to evidence that's relevant from that time, detailed. And if you're looking later on at possibly moving from exclusion to prosecution, that's going to be another big challenge in reality. The case of Karadzic, also very interesting to keep in mind because you're looking more at the political level than the operational level in terms of complicity of a leader in genocide. ICC new situations, I think Joseph made plenty of references to the ICC. especially with co-perpetration and how we have to be careful about how it's gonna influence maybe exclusion cases, and I don't know what impact you may have also in our future. Because when we talk about the guidelines from the UNHCR, yeah, one of the challenges is how the jurisprudence is going to evolve, and we have new types of cases coming up. We got the Libya situation that was referred to the ICC. You also have Sudan. This one is a little less clear about Sudan, but it tells another story. This is from Project Sentinel. It's a different way of gathering evidence. This on the picture is actually of a mass grave. It's from a picture that was issued last month. Project Sentinel is basically from a satellite taking tons of pictures of Sudan and being analyzed to determine where crimes are being committed, where mass graves are located, etc. And this basically brings in new technology into the equation of evidence, because IC cases are not necessarily exclusion. They can be linked to organized crime and immigration law, where you see Facebook as evidence, you see YouTube videos as evidence. Technology is having a massive influence on how the future may determine some of those cases. IRB, the reform, just something to keep on the radar. What's next after Isacola? Because Isacola did one thing that's interesting. In the first level, the parameters of the net were set. You saw an end to the net. In the Federal Court of Appeal, you see, this is just a personal opinion, but I don't see necessarily an end to the net clearly determined. I'm still looking for that Federal Court of Appeal or that Federal Court case that's going to clearly establish what are the different forms of complicity you can use, what are the elements you need to prove for each of them in exclusion, and not just focus with one situation at a time. But while we're waiting for such a decision, maybe we're going to have to take our own initiative and draft policy that will address those tests for our practitioners so they can apply exclusion law in a clear and consistent fashion. And that also includes UNHCR new guidelines, just something to be keep aware. I'm very looking forward to these ones. Advanced training in government. For CBSA, we used to have national war crimes training every year. For the last 2 years it didn't happen, but it's going to resume in September. And the goal is basically just to ensure that we have several offices across the country that work on war crimes cases. One in Toronto, we have specialized units in Montreal and Vancouver as well. And to ensure consistency, you need to make sure that those teams talk as well. And national training is part of that strategy. New academic publications and research. The project that's happening at this university is very important for us. Very interested in the developments of that project. Also, I know like new books are coming out. And IGC. I was at that conference in June. It was extremely helpful to sit at the same table as many people working in the same field from different countries. And it was a great opportunity to network and see where we should move forward as a group and to ensure better consistency. And finally, what I'm looking forward to is more conferences like this one. Because when you work in the field of exclusion, sometimes you feel a little bit isolated, even if you have special units. And because ICL on the, let's say, on the shadow of exclusion moves so fast and there's so much jurisprudence developing, it's important to have events like this where people can just network, get updated, have access to other knowledge and other ways to address their own challenges. And basically, I guess my main message is this, is that the closer ICL and exclusion are to one another, the more integrity there will be to exclusion. However, there are some challenges with that and they'll have to be addressed as a group. And I must say that even if I work in, let's say, an enforcement office, my message to staff has always been the same. When you work on exclusion, you work on inadmissibilities. Your work is not to make people inadmissible, your work is not to make people excluded. You're there to make the right decision. And that nice wording came from one of my early mentors, Jeffrey Nice at the ICTY, in the Milosevic case, where basically his goal and his message was clear: we're not here to win the case, we're here to get the right decision. And I think that's one of the most important things to do when you're working on exclusion, because it's not just about getting the stats, or moving on to prosecution, there's a refugee claimant, there's a family involved, and basically there's a lot more impact to exclusion than just stats. So, thank you.